Okay. So we were discussing the banker's duties and rights under the banker-customer relationship. The last Saturday we discussed bankers' duty of secrecy. So then we have to continue from there. So we'll see the what is the next duty cast upon the banker under the banker-customer relationship. The next one is duty of care. So as a banker, when you are performing duty, the bankers and the bank has a duty of care towards the customer. So this is very important point or duty cast upon the bankers, which has been recognized and also implemented by court of law in many cases. So it's a established law in the country and universally also. Even though that duty you have not mentioned in your agreements or anywhere, this is an implied duty cast upon the bankers where you can't deny. You can't say that we don't have any duty of care towards our customer. It is the customer's right. It's a customer's duty or customer's choice. You can't say so. You have a duty of care in certain occasions when you are performing your duty as a bank. We'll see what are the situations or what are the examples that we can give where you have to perform your duty with due care. So, for example, the bank, the paying bank has a duty of care to protect the customer from the frauds and of agents such as directors and partners in issuing checks and other payment orders. What is this? Now, if you take a check transaction, you know, there are two banks involved. That is the issuing bank or the drawer's bank and the paying bank. Paying bank is the bank that pay the check of the customer. It could be the same bank, collecting bank and paying bank. The paying bank has a duty when you are paying a check of a customer, you have to protect the rights of the customer. Customer means the account holder, current account holder. You have a duty to protect the customer. You can't put the obligation on the customer and say the customer it is customer's duty to protect himself from any fraud. It is not so. For example, the bank has a duty to protect the customer's right from any frauds of agent of the customer, and also the agents like directors, partners of the business. Now, for example, we say we have a customer who is a corporate customer. We say it's a company, and the company has given the authority to issue checks to a director. We say we have 3 directors in the company. The company has given an authority to issue checks on behalf of the company, and the authority is given to one director. So now, who is our customer? Our customer is the account holder, not the director. Account holder is the company. So our obligation is to protect the right of the company, not the director. So we say when we are paying, we got a check from the company. It has been issued by the company account, signed by the director, authorized signatory, and the beneficiary or the payee of the check also same director. So basically, the authorized signatory is issuing a check in favor of himself, and he is taking money from the account of the company. Now, in a situation like this, what is our duty as a bank? So always remember that we have a duty of care towards the customer. So who is our customer? The customer is the company. So this, when you take this scenario, this the facts of this transaction, you see there is enough. So there are enough facts that suspicions can be created in a mind of uh, uh, a banker. Now you see, you have to think. Now this could be a fraud. So therefore, remember that we have a duty to protect the customer. So therefore, before you paying a check like that, we have to do a proper inquiry about this check. So we have to basically, you have to get a clearance from the company and pay the check. So same if you are paying a check of to a partner of a partnership. So the same authorized signatory who is a partner of the partnership issues a check from the partnership account to his personal name. So then your duty to is to protect the account holder. So therefore, you have to make a inquiry before you make the payment. So that is called duty of care. And also bank owes a duty of care when you are giving financial and investment advices. So do we give financial advisors and investment advisors? Yes, we are giving investment advisors and also financial advisors to the customer. Sometimes we actually don't know, or we have no intention, or we don't know any knowledge, we don't have any knowledge that we are providing financial or investment advisors. We just advise the customers, but actually those are investment or financial advisors. For example, we say customer comes and asks, what I have some money with me, so I want to deposit this money in a fixed deposit. What is the most profitable way to deposit the money? So you advise the customer. You say, okay, if you put this in a fixed deposit, this is the rate that you can get. So if you put in a we say you have a product, something power saver, we say something like that, right? So if you say that we have a product called power saver, if you deposit that money in the power saver account, that you can get more 3% more interest for the power saver account. So likewise, that is advice that you give to the customer, and it is an investment advice. Remember that. So it's not just an advice. So investment advice. So investment advisors and financial advisors, when you are providing, remember that you have a duty of care. And you, based on your investment advice or financial advice, the customer may decide to invest or invest money in a particular account or product. So if he lose money after investing that money in that particular account, based on your advice, that he can sue the bank on breach of duty of care under the banker customer relationship. So we have a case. Actually, the case is over now that I appear in that matter. What has happened in that matter? This a lady who retired from her employment, she got a retirement benefit. Say if I remember correctly, 5 million rupees, and she came to the bank and she met the manager, and she asked, this is that I got from my retirement, so I want to invest this money, and from the income I'm going to live hereafter, so therefore give me an advice what is the best way to invest this money. And she said, so then the manager advised her. Then manager said, if you put this money, all money, 5 million rupees under your name, what will happen? that you have to pay taxes because it exceeds the threshold limit. So therefore, you have to pay taxes. So if you then the customers, how can you advise me? How can to avoid taxes? How can I do that? So then the bank manager advised her to deposit that money, 1 million each, in different people's name. So actually, then what she did, she deposited certain money under her name, her husband's name, and also under her son's name. So then thereafter, what happened? This son met with an accident, and he died. So then, after the death of the son, the widow of the son claimed the money. Now she doesn't know that the money has been deposited by the mother-in-law. She claimed the money. She said, "This is my ex-husband's or late husband's money. So I am the legal heir. So I am entitled for the money." So the mother said, "This is my money that I invested in the account of my son based on the advice given by the bank." So what happened with this dispute? Because of this dispute, mother filed action against the bank, claiming the money and also damages for wrong advice given to her. So then, actually, what happened? It was in favor of the customer, that account holder. So ultimately, luckily, the matter was resolved between the mother-in-law and the daughter-in-law. So then, because of that, the bank didn't have to pay damages. Otherwise, what would happen? The bank could have paid damages also. So therefore, remember, when you are giving advices, it is not just an advice. You have to be very careful. It's a duty that you have towards the customer when you are giving financial and investment advices. So always give correct advice, and don't try to help the customer by advising the customer to do illegal thing like avoid taxes. So we used to do this, but one day if something goes wrong, the customer will sue the bank. So therefore, and also then you will be in trouble if you have given the advice. So then the bank will take action against you. So therefore, it is my advice is always give correct advice and give advice with due care. Then the third one, the banks owes a duty of care in explaining the effects of the security document. This is another important thing that you have to remember. This is a duty asked upon the bankers. Actually, we don't know that we have a duty like this. I have experienced this. Now, if you take an example, a customer comes to get a loan. So you ask the customer to bring we say personal guarantors. The guarantors. Then you take guarantee bond. Have you ever explained the effect of the document to the guarantor? My experience is the bank officers never explain the documents to us. They say, this is a guarantee bond. You sign here, and you show the places that we have to sign or initial. So we initial those places that you show. Then you take the documents, and we most of the time we don't get a copy even. So what is the duty of the customer when you are taking the security document, including loan agreement, overdraft agreement, and also collaterals? So it is the duty of the banker is to explain the effect of the security document. So, for example, if you take a guarantee, that you have to explain the effect of the guarantee. So, what will happen if you sign as a guarantor? What is your legal obligation, and so on. So to explain that, first of all, you should know what is the legal effect or the effect of the document that you take. So therefore, so every banker has to educate about their collaterals. Now, if you take an indemnity, what is the effect of the indemnity? Hmm? What is the difference between the indemnity and the guarantee? These things that you have to explain. Now, for example, another example is if you take a mortgage, what is the effect of the mortgage? If it is a first party mortgage, what is the effect? If it is a third party mortgage, what is the effect of the document? And if you take a letter of set off, what is the effect of that document? Likewise, that you should explain the document, the collateral that you take, the effect of the document you take to the customer. That is a duty. It is not necessary the customer to ask that. It is our duty to explain him what is the effect of the document. If you don't explain, that he can take that as a defense in his case. Now, in the most of the cases that we file in courts on behalf of the bank, the customers come and take the defense. They say that the documents were in English language and the documents were not explained to us, and therefore we are not bound by the agreement or whatever the document. So the bank officers, their attitude is, if the customer has signed the document, that he is bound by the document. This is a wrong idea or wrong attitude that we have as bankers. This I have explained. Always the bank officers say, what is the big deal? The customer has signed, his signature is there. We verify the signature. It is the same signature. Two of our witnesses also have witnessed the document. So therefore, it's not a big deal. The court should accept that. These are the words that the bankers use. Court should accept the document because it's very clear. So actually speaking, court will not accept the document unless it is proven and unless it has been executed as per the legal procedure. So if you have not explained the document, that is a good defense, that the customer can take in a case. So remember that. So that is number 3. The banks owes a duty of care in explaining the effect of the security document. So if you have any questions from this slide that you can ask, if you want more clarification or more examples, or otherwise I will go to the next one. The next one, yes.
We have seen that some banks are obtaining signatures on a rubber stamp when the document is in English, and the stamp says "Kiyawa Terum Gatimiyo Kiyawa Avbodha Karaga Dun Pasuwa Atsan Karami," something like that. So, is it valid in the courts?
Yeah, a very good question. Actually, this practice has been developed as advised by the legal department. You know that when we go to courts, that we see every day that this defense takes in courts. So they say that we don't. I can't read English. I can't write English. So documents were in English. They asked me to sign. I signed. I don't know what was that document. This is a defense that they can take, which is a valid defense in court of law. So to overcome what we do, the legal department may have advised you to get that wordings in Sinhala. We say Kiyawa Terum Ganimen Pasu Atsan Karami. Or otherwise you say Kiyawa Terum Karadun Bavat Terum Ganimen Pasu Atsan Kala Bavat Prakasha Karami. Then you get the signature of the customer. The ideal situation is you ask the customer to write that words in his handwriting. So that is the best way. But the problem is sometimes the customers, the writing is so bad, or sometimes they can't write. So even in Sinhala. So in a situation like that, so what we do, we get this rubber seal and we place the rubber seal and ask the customer to sign where the signature has to place in the rubber seal. So then the situation is the customer, if he says or he or she says that she doesn't know English, but this part is in Sinhala. So which is very clearly says, Kiyawa Therum Kara Deemen Pasu Atsang Kalani. So then later on that customer defense, if we take that defense, that we can counter argue that you have signed after explain the documents to you, you have agreed to that sentence and you have signed, so that we can use that against the customer. It is called estoppel. Estoppel means once if you accept something, then you later on you can't deny the same. That is a law principle which is called estoppel. So basically, he or she has accepted the document has been explained to her, or him or her, and has signed. So then later on, he or she can't say that it was not explained to me. So that is why we place that seal. Best thing, if you can get that in the handwriting of the customer. If it is not possible, and it is also it is easy to always to place this seal and the customer sign on the seal itself. So that is very important. Yes, we can use that. We are using that as a to face the defense of the customer in court of law. Is it clear?
Yes, sir. Thank you.
Yeah, that practice is good because then we can use that the practice that wordings against the customer in court of law. Any other questions?
So excuse me, sometimes now as a practice in some leasing companies, they get the signature on blank sheets, and then after processing the lease facility only they print the document. This is also a common thing. I think I have seen that.
Yes. Honestly speaking, that is a wrong practice, which can be used against the finance company or the bank. Even sometimes banks also, we have seen this thing happen. And not the entire documents blank. Sometimes, for example, interest rate. So they decide the interest rate at the point of granting the loan, but the loan agreements and other things signed before. So that place you kept a blank and you get the initial there, then thereafter you fill. The worst case is, as you said, in some finance companies and also leasing companies, they get the signature for the blank document and then later on you fill it. Two things can happen, can go wrong. One, sometimes you forget to fill this document and you issue copies to the defendant. So in a situation like that, you are in very bad condition, because that person can bring the document signed with blanks and can show to the court that the documents has been filled by the company without the agreement of the customer after obtaining the signature. So later on, the company has filled the blanks. So in a case like that, the agreement is not valid, because agreement is not completed at the time of signing. So that one thing can happen. Or the other thing can happen. Nowadays, everyone, they have smartphones with cameras and all. So when they sign, especially if you give the documents to the customers and sign and bring, what could happen? So they will sign the document. After signing the document, they will take photos of those documents. I have done this. So remember, it's very dangerous. As much as possible, to always get the signatures to the filled document, or otherwise don't give copies of the documents if you get the signature for the blank documents. And third one, always fill the document once you get the information. Don't keep that document in blank uh, for a long period. So I have come across situations. The banks refer the files to the lawyers. When we go through the documents, we see certain places have been kept blank. So then we ask the bank to fill that. Then they take the documents back, and thereafter they fill the documents and bring back. So we see the handwritings are different. So likewise, they also can, the defendants, the borrowers, they can challenge these documents in courts of law. When you see see a document filled by different people with different handwritings and different colors of pens, so then it is obviously that shows that the document has been filled in different occasions without the consent of the customer. So therefore, my advice is, this is a practice, yes. Don't give copies. Don't send the documents to the customer's place to sign and ask the customer to bring the document after signing. Don't send blank. Then third one, be careful. If you take blank documents, always fill the document, complete the document before you file the document in records. That is my advice. Any other questions? Okay, then we'll go to the next one, the banker's duty as a trustee. Now, the banker has a duty as a trustee, especially banker is a trustee with regard to the safe custody of the deposits and goods. So we provide the safety locker services to our customers. So customers, they bring their valuables and they keep these valuables in the custody of the bank. So we are, what is the relationship here now? The banker's relationship with the customer, when you are providing safety locker services, we act as a trustee. So trustees, the duty is to protect the goods of the principal. The principal is the customer, his property on behalf of the customer. So that is very important. If we misuse the goods, or if we lose the goods, the valuables of the customer, as the trustee, the bank is liable to pay that to the customer, and also sometimes we have to pay damages also. For example, we say the customer, we have given a safety locker facility to a customer, and customer has kept his all title deeds and the plans and everything in the locker. So, however, the locker is it has a dual control keys, and the customer can't just open the locker. He has to come to the branch, and you have to sign in a book, and then only the bank officer and the customer can go and open the safety locker. So it is very clear, customer cannot open this locker unless there is an involvement of the bank officer. But when it comes to the bank side, we know even without the customer, we have sometimes we say there are no duplicate keys, but actually there are ways that we can open those safety lockers also. However, the important point is, since the documents or the goods are in the custody of the bank, we are keeping those documents as a trustee or as a custodian. So therefore, the obligation is on the bank. So if you damage the document, if you lose the document, or if you lose the valuables of the customer, we are liable as a trustee. The bank has to hold the deposits and goods of the customer on behalf of on behalf of him. So the money deposited in the account also we are keeping as a trustee. If a bank staff misappropriate the funds of the customer, that is a breach of trust. So who has breached the trust? It is not that particular employee. The bank has breached the trust. So then the customer, if he lose the money because it has been misappropriated by a staff member of the bank, so the customer will sue the bank, not the staff member. So if a customer lose the money, he file action against the bank. The bank can't say that one of our employee has misused the fund, so therefore we are not liable. It's the liability is that particular person, and you have to file action against him. That is not an acceptable defense in courts. So the obligation is cast upon the bank as a trustee. Then the bank has to act according to the instruction or the mandate of the customer. So this is another important thing. When the money deposited to account, or if a customer has given valuables to the bank for the safe custody, the bank has to obey the instructions of the customer. So if you breach, or if you don't obey, or if you ignore the instructions of the customer, that itself is a breach. So therefore, the customer can sue the bank. The bank can be held liable for the theft, misappropriation of the goods or money by the employees during the banking business. So therefore, remember, the misappropriation, theft by the staff of the bank, the liability is with the bank or on the bank. So bank has to pay the customer, and also customer can ask damages if misappropriation or theft has happened or has done by the staff of the bank. So that is the banker's duty as a trustee. If you have any questions, you can ask from here. Or otherwise, I will go to the next one. The banker's duty as an agent. So we act as a trustee. The banker act as an agent also. So when we are acting as an agent, on what occasions we act as an agent? When we say agent, whose agent? So the bank, act as an agent or the customer. This is very important. With the banker, the customer and the banker, this is a special type of relationship, that is a principal and agent relationship. Under the principal and agent relationship, the banker is the agent, or bank is the agent, the customer is the principal. So basically, agent has to follow the instruction of the principal. Principal is the customer give instructions to the bank has to follow the instructions of the customer or the principal. The bank is an agent of the customer for the remittance, collections of checks, and payment of the customer's behalf. So when you are remitting money, when you are collecting checks and bills, and when you are paying checks and bills, we are the agent of the customer. So we have to follow the instructions of the customer, and the customer, the principal, has a right to command the agent and give instructions. Now, for example, customer can issue a check and give advice or instructions to the bank as the agent not to pay the check. He can stop the payment. So we have to abide by the instructions of the principal, because we are the agent. We are the agent when we are paying the checks on behalf of the customer. So we can't just ignore the instructions of the principal and pay the check. If we do that, that's a breach of duty as an agent under the banker-customer relationship. The customer then can sue the bank. Then the bank, as the agent of the customer, has a duty to act for and on behalf of or for the benefit of the principal, that is the customer. When we are doing any transaction on behalf of the customer, remember, that we are the agent of the customer. So agent's duty is to protect the right of the principal, and agent has to do any act or any avoid any act to protect the right of the customer, that is the principal, and for the benefit of the customer. That is that we have to remember. So whatever the step we take with regard to the customer's account, the benefit should go to the customer. So there are exceptions for this. For example, if we set off under the banker's set off, the benefit goes to the bank. So there are two two rights which has conflicting rights. The customer has a right as a principal. The bank has a right under the banker-customer relationship, right to set off. So banker's right to set off will supersede the customer's right here. Or otherwise, remember always, the bank is the agent of the customer. Customer is the principal. Bank has to follow the instructions of the customer as the agent, and the agent has to act for the benefit of the customer under the banker-customer relationship. If I summarize that is called banker's duty as an agent. So if you have any questions from here, you can ask now. We have now finished the banker's rights and duties. Do you have any questions from here? Okay, if you don't have any questions, then we'll go to the next one. Right. Next, we are going to discuss about the duties of, sorry, to start from here, the customer's rights and duties under the banker-customer relationship. So you may remember the order of topics that we discussed. First, we discuss under the banker-customer relationship, who is the banker, then what is the who is a customer, what is banking business. Then we discuss the banker-customer relationship, the nature of the banker-customer relationship. Then we said it is a contractual relationship. Then we discussed, we said under the banker-customer relationship, the banker and the customer, both they have rights and duties. Then we took banker's rights and duties. We now discussed and finished. Now we are going to discuss the other part of the banker-customer relationship, that is the customer's rights and duties. What are the customer's rights and duties under the banker-customer relationship? So we'll see what are those rights and duties. Now the first one, customer's right. Under that, I have given the first one as opening an account. Customer has a right to a right called opening an account. When we say the right of opening an account, don't misunderstand that the customer or any person has a right to open an account under this. It is not the case. When we say the customer's right to open an account, it means if you allow a person to open an account, that means if you create a banker-customer relationship by allowing him to open an account, then what is his position? So then what happens? He becomes a customer and he gives a mandate to the bank. The bank has to act according to the given mandate. Now, this is his right. When he opened an account, we have a banker-customer relationship. Customer has a right to give a mandate to the bank. The bank has to act according to the mandate, given mandate. Now, I ask a question. This is an exam question also. So my question is very simple. What do you mean by mandate? Can someone explain to me what is mandate? What do you mean by mandate? Can someone please answer? Can someone answer to the question? What is a mandate? What do you mean by mandate? I'm sure there are bankers here. Any banker wants to try? What is a mandate?
It includes the detail of a customer.
Can you repeat, please?
Yeah, it's a document including the details of the customer.
Okay, you are referring to the document that you obtain at the time of opening the account. It's a document and it carries the details of the customer and he sign and give to the bank. Is that correct? Is the document that you are referring?
Yes, sir. Yes, sir. Yes.
Others? Any other?
And that is an application to opening an account, and that is included bank term and conditions, and customer accept that term and condition and opening an account.
What about the signature card? Is it also included to the mandate or not?
It should be included, sir.
Yes, it is
should be included.
Yeah, okay. You said, you now said 3 documents: application, terms and condition, and the signature card. So you say all 3 documents, if you take together, it's a mandate. Is that correct?
Yeah, KYC, mandate, the KYC signature card, and this the application. No, I think all the documents.
Okay. So
as a mandate.
You now add another document, KYC also, right? Now 4 documents: application, terms and condition, signature card, and KYC. Anything else?
So its mandate is an authority given by the customer to the bank to operate the account on behalf of him or her.
Okay, very good. Now you see this. I said exam question, and the answer is the last answer given by that lady. You see that our practice or our banking practice is we call that document as a mandate. When we say what is a mandate, you give a general answer based on your banking practices. What you said is correct when it comes to general banking practices. The document you take at the time of opening the account, which carries the details of the customer and terms and conditions, and the signature, and also KYC that you attach to the same document, you take and you call this as a mandate. But when it comes to law, remember, the mandate is different. If you get a question at the exam, what is mandate? The mandate is the authority given by the customer to the bank to operate his account on behalf of him. That is the definition that you can give to the mandate. Now you may have heard that the government or the news, if you see news, they say the new government has the mandate of the society to run the country. What does it mean? But we have not given any application form or terms and conditions signed to the government. So we vote. So by voting, what we are doing? We have given the authority to the government to run the country for a period of time on behalf of the society or the general public. Everyone can't go to the parliament and sit there and decide, all 22 million people. So what we do, we select some some intellectual people, very wise people from the society, and select them and send them to the parliament to run the country on behalf of the society. So we give them an authority. So that authority is called the mandate. So likewise, the customer, when he opens an account, he gives an authority to the bank. Now, if he opens an account, my next question, if you allow the customer to open an account, who is the owner of the account? And can someone answer to that question? You allow the customer to open an account. We say Pereira. Mr. Pereira opens an account. Whose account is that? Can someone please answer? Can you hear me?
Mr. Pereira is the.
Okay, it is Mr. Pereira's account. Okay. So then, who is operating the account?
The bank.
Huh? Can someone answer? Who is, say, Mr. Pereira wants to deposit money.
The
right?
bank.
Who is operating the account?
The bank.
The bank, right? So basically, the account is owned by Mr. Pereira, but it is operated by the bank officers, right? We give to the, so Mr. Pereira go to the, forget about these special services like ATM machines, cash deposit machines, right? Normal banking practice. He goes to the teller, fill a deposit slip, and give the slip with the money to the teller. Teller takes the money, and she or he operate the account and do transaction, debit or credit, whatever. So actually, the account is owned by Mr. Pereira, and it is operated by the bank. So where we get this authority to operate other people's account? We get that authority at the time of opening the account. Customer gives a mandate to the bank to operate his account. How does he give the mandate? By signing those documents, the customer give that authority to the bank. So like we gives the mandate to the government by putting a cross in the ballot paper. Likewise, the customer gives the mandate to the bank to operate his account by signing that document or documents. So the mandate, the definition for the mandate is customer's mandate. The customer, the authority given by the customer to the bank to operate his account on behalf of him. So that is called a mandate. So the definition is very clear. Customer gives a mandate to the bank to operate his account on behalf of him. So in other words, the customer has a right to give instructions to the bank, and the bank has to act according to the given instructions of the customer. That is the first right of the customer. Customer right to open an account. So in this regard, there is a case that you have to remember. This is a very important case. When I say important case, that you have to write that in the exam also. It is Hugh Reinburn versus Federal Bank of Australia. In this matter, what happened? The customer's account was overdrawn, and this customer deposited money into his account. You know, when the account is overdrawn, if customer deposit money to the account, what will happen? Automatically the OD will get set off, or you will reduce the OD by absorbing the money deposited. So what happened here in this matter, that this person, he deposited money into his account, irrespective that his account was overdrawn, he gave a specific instructions to the teller. He gave the money and he said, deposit this money and don't deduct this OD from this money, because he said, I have issued the check and check will come to the account soon. Once the check comes, you have to pay the check. That is the specific instruction given by the customer to the bank. Now you may think, if customer has a right to do that when his account is overdrawn, these are the questions that we get normally. But remember, under this banker-customer relationship, the first right of the customer, he has a right to give instructions to the bank under the right of opening an account. So this customer gave specific instructions to the bank and deposited the money. Then what happened? The manager, without informing the customer, set off the OD against the deposit. So irrespective of the instruction, ignoring the instruction given by the customer, the bank manager set off the OD. Then next day the check came, check got returned, and then customer filed action against the bank, and it was decided in courts the bank has no right to set off and the bank has to abide by the instructions of the customer. So therefore the bank act to set off was wrong, so customer claim damages and the money from the bank. So now you see there are two conflicting rights. The bank has right to set off, customer has right to open an account. So these two, when there are two conflicting rights here, the court has decided the bank's right to set off, the customer's right to give instructions to the bank will supersede the bank's right to set off, because he has given specific instructions. That's why I said under the banker's right, though banker has a right to set off, that right to set off, right to combine, those rights are subject to certain limitations, conditions. If a specific instruction has been given by the customer, the bank right to set off will supersede by that the specific instruction. So that is customer's right to open an account. Any questions from this one?
Excuse me, sir.
Yes.
Has that instruction need to be in written or verbal?
It is a good question. Now in this case, this customer gave the instruction, verbal instructions to the teller, right? The teller has not communicated that to the manager. So it is not necessary to be in writing, but in most occasions, customer give instruction in writing. For example, we take a situation like this, customer gives instructions to stop the payment of a check. We say countermanding. So what is our experience? Sometimes customer give a call and ask us to stop the check, payment check. So the question is whether we can accept that verbal instruction, telephone call. Legally, customer has a right to give verbal instruction. Our position is, as a bank, we have to act on instructions of the customer. So therefore, we have to accept the verbal instruction, and also we have to protect the rights of the bank. So therefore, you act according to the instructions, verbal instructions of the customer, but you inform the customer that he has to give instruction in writing also. So therefore, you follow up and get that instruction in writing. It is not necessary, it is not mandatory to give instruction in writing. Verbal instructions is legally valid. So therefore, the simple answer to the question is, verbal instruction is enough. If I further elaborate, to protect the right of the bank, always get written instructions. Is that clear?
Yes, sir.
Right.
Excuse me,
Okay.
sir.
So then, yes.
So the customer can lie now, sir. But we use only if you're going through verbal instructions only, the customer can lie also.
That is another thing that yes, what you say is correct. So that's why we say to safeguard the interest of the bank, you always follow up and get that instruction in writing. So customer later on can say that I never give that instruction. So then how are you going to prove? So therefore, so that's why we say you have to accept instruction, verbal instruction, and also same time you inform the customer that we'll accept your verbal instruction, but as per our policy, you have to give written instruction. Then you have to follow it up and get the written instructions also. So yes.
So I think we used to receive through the relevant AROs. So I think we don't bother about those things, right?
What do you mean by ARO?
The company we have given some companies to particular persons to handle, no?
Yeah.
The retail customer,
ARO
corporate
is a
customer.
relationship officer.
Yeah. So
okay, the relationship officer is a employee of the bank. Is that correct?
Yes, sir. Yes.
So what you are saying is that customer give verbal instructions, the ARO has to follow it up and get the written instruction from the customer.
Yes, sir. So in our bank, we used to get those details through the AROs. So according to the ARO introduction, we do, sir. That's what I came to say.
Right. Okay. So anyway, what you are saying is you are accepting customers' verbal instruction, but later on the ARO will get that instruction in writing.
Yes, sir.
Right. Yeah. As long as you get the instruction in writing, then you are protected, because then you have a document in case the customer later dispute, that you can produce the code. Or otherwise, what will happen? It's very difficult to prove that the customers the verbal instructions. So what you have to do is, if you get a verbal instruction, if it is a via phone call, the recordings should be available, phone call recording, or the bank officer should put a minute, and the same can be testified by a senior officer. So then there are two officers of the bank who can come to courts and give evidence and testify that you received verbal instructions from the customer to act given instruction. So you acted according to the verbal instruction. If you fail to get a written instruction, that's how we prove in courts. We bring witnesses and give evidence in courts. So that is the answer for that. How you are going to prove a verbal instruction in courts by evidence. Any other questions? Right. If you don't have any other questions, then I'll go to the next one. Then the customers right, second one, to stop an account. Customers right to stop an account. What does this mean? Customer can seize the debits and credits of the account until further notice. Now, stopping an account and closing an account are not the same. Those are two different scenarios. This is a right of the customer where he can stop debit and credit of his account for a certain period of time or until further notice. That is a right of a customer. So customer can give instructions to the bank and say, please stop debit and credit of my account. So debit and credit, if you freeze the debit and credit, that means you are freezing the transaction. Nothing else you can do, no? Only credit and debits that you can do perform in the account. So he has a right to do that. Even so, for example, we say the customer's account is overdrawn, right? OD. The customer said don't do any transaction, debit and credit please freeze the account or stop the account for a certain period of time or until my further notice. So the bank should immediately stop the account once the mandate is revoked. The mandate is revoked means the customer gives a mandate to the bank officers at the time of opening to operate his account. Operate his account means you are doing, the bank officers, they are operating means that they are doing credit and debits. Now he has given instructions to the bank, not to do any debit or credit. So that means that he has taken back the mandate given to the bank, revoked. So therefore, the bank has no authority, the bank officers have no authority to operate his account. So therefore, it is illegal to operate his account once you get this instruction. The bank should not honor any checks or pay any standing orders during this period. Now we say the customer has given instructions to stop the account. So if you get a check during this period, that we have to return the check. Account stop. You have to put that narration and you have to return the check. You can't honor the check. And also, if customer has given standing orders, you can't pay the standing orders also during this period. This is very important. The bank can debit the account only to recover the losses or charges occurred before it received the stop notice. This is another important point that you have to remember. Now we say the customer's account is overdrawn, and all of a sudden customer gives instructions to the bank to stop the account. Now you know that if it is overdrawn, we charge interest. The question is whether we can charge interest during this period if he has given stop account instruction. It is very clear the bank can charge or we can debit the account of the customer to recover the losses, charges occurred before it received the stop notice. Now you received stop notice today. By that time it was overdrawn. We say it has been overdrawn 2 weeks back. Definitely we charge interest. So the interest due.
Excuse me, sir. That means we stop before the payment. We used to charge, even if it is a next month charge. Also, we charge. Is it?
Can you repeat?
Before it generate the charge, also we charge. Is it?
Not clear. What can you just explain what you are saying?
Yes, sir. According to this thing,
yes.
So customer coming to give the stop the payment. Stop an account. Stop an account mandate.
Yes.
So customer has given the standing order request instruction for the particular period.
Yes.
For that we are charging some kind of charges from the customer.
Yes.
So in that case, we take August month charges we have to take. So before we close his request, do we need to take that charge?
No. It's not like this. For example, I will explain this, right? Now we say customer has an account, right? He is operating the account. He has given standing orders, right? And we charge charges for that, right? We say customer give stop account instructions today, right? Now we can't do any debit and credits, but tomorrow we say charges for the standing order will come to the account, so we have to charge that. The question is whether we can charge that because now there is a stop account instruction. Under this, we can charge or we can debit the customer's account and recover that charge because that charge came due before we received the instruction of stopping the account, because he has given the standing order before he stopped the account. So charges for that particular service is due to the bank before he gives to before he gives the stop account instruction. Now that is one. We say the customer's account is overdrawn. So when the account is overdrawn, we charge interest. Normally what happens, we charge the interest at the end of the month, right? We say today, now it is 18, the customer's account is overdrawn and he gives instructions to stop the account until further notice. Now what is the situation? At the end of the month, we have to charge OD interest. The question is whether we can charge OD interest, debit the customer's account and charge OD interest because he has stopped the account. The answer is yes, because his account is overdrawn before we receive the stop account instruction. So therefore, interest is due on the OD. OD occurred before we received the stop account instructions. So therefore, we can debit the customer's account at the end of the month, even the account is stopped, and recover that. So then that is for the overdraft. Now we say another situation, his account, he has 1,000 rupees. He gives instructions today to stop the account, right? Now there is a balance of 1,000 rupees and tomorrow we received a check. Now we know that when the account is stopped, we can't pay. However, whatever the reason, we pay by overdrawing the account. Now the account is overdrawn. The account was overdrawn after we receiving the stop account instruction. So therefore, we can't now charge interest for that. So because that charge or interest has occurred after we receive the stop account instruction. Clear?
Yes.
Are you clear or you are?
Yeah, sir. Thank you, sir.
Right. Okay. So during this period, if the account is stopped, the only thing that we can recover by debiting the customer's account, we can recover the charges and interest which occurred before we receive the stop notice. So basically, if we credit the customer's account, he won't challenge. If we debit the customer's account and if we take money from his account, only he challenge. So normally that is the practice or that is the way. So remember, we can't debit the customer's account or debit or credit. Both we have to stop. We have to cease if we receive stop account instruction. The banker-customer relationship, what happened to the banker-customer relationship during this period? It is very clear. It is the stopping an account is not a closing an account. Stopping an account is a temporary thing. There's a temporary stop of credit and debit of the customer's account for a short period or until further notice. So therefore, the banker-customer relationship is prevail or it is there. So therefore, all the rights and duties of the bank and all the rights and duties of the customer are prevail. So therefore, including duty of secrecy, all rights and duties of both parties are prevail because the banker-customer relationship is continued during this period. So that is about the customer's right to stop the account. If you have any questions on this, you can ask, or otherwise I'll go to the next one. Next one is the customer's right to close the account. Now, this is different from stopping the account. Customer has a right to close the account. Closing of account is a permanent thing. Once, if customer gives instructions to close the account, or if bank decide to close the account, bank or the customer can close the account. Once you close the account, banker-customer relationship comes to end. That is a permanent thing. So, not like stopping an account. Customer can close his account at any time. This is very important. Customer has a right to close his account at any time. Customer does not want to give, or customer has no duty or obligation to give prior notice to the bank. Customer can just walked into the branch and say that I want to close my account now. So that is his right. You can't say that you have to give prior notice, we have to arrange money. So likewise, you can't delay immediately that you have to close the account because it is his right. Of course, yes.
But sir, some banks charge for that also. Some
Yeah,
other banks are because they ask him to do keep the deposit amount some kind of. Otherwise, we have to pay such an amount and we have to close.
Yeah, I know what you are saying is that there's a minimum balance that you have to keep in your account. If you don't keep that minimum amount, they charge fees that is called minimum charge fees. And if you don't continue, if you don't maintain the minimum balance, then they ask to close the account. That's what you said, no?
Sir, I have 2 accounts, one of bank.
Yes.
So I'm not used that.
Yes.
So I told them I don't no, I don't have any interest to use. So I need to close that account. Then I will issue the letter.
Right.
So they said no, you have to keep some deposit. After that only you can close. So after that I don't keep any accounts. So it's always remain anyway. If they want, they will close. No, so I keep it remain.
Yeah, is it a savings account or is it a
if I say those kind of things, the bank will come out, sir.
Okay. Right. Okay. So if it is the thing is, if it is a current account, we have to be very careful because if the money they utilize to deduct the charges, one point, if there is no money, then thereafter it can be there can be a OD balance. Then the OD balance can be accumulated. Every month they charge OD interest and other charges by overdrawing the account. They take money. So then the OD balance can increase. So then you are liable to pay that money. So if it is a current account, if it is a savings account, then if there is there is a condition that you have to maintain the minimum balance. If you don't pay if you don't maintain the minimum balance, they charge fees. Then ultimately, if you want to close the account, they ask you to pay the charges that charges can be accumulated over a period of time. So therefore, you have to be careful. Anyway, if you have
max bonus accounts kind of stuff, is that coming under?
Sorry?
Max bonus account.
Max bonus account.
Yes.
Basically, different banks, they have different products. You have to see the terms and conditions of that particular account when you are opening. For example, we say you have a cash build-up account or salary saver account, or there are different types of accounts with the banks now. So there are particular terms and conditions. If it is say that you have to maintain the account at least 5 years time, if you have signed the terms and conditions, that means you have a separate contract for that particular account. So in a situation like that, it supersedes the general terms and conditions under the banker-customer relationship. So that may be the reason, or otherwise, if it is a general savings account or current account, the customer has a right to close his account at any given time. But of course, if it is a special type of account, it subject to the terms and conditions that you have agreed. For example, if it is a fixed deposit, you can't just terminate the contract or close the account. So if you have agreed to keep that money for 5 years or 10 years or whatever, before that, you can't withdraw the money. If bank says no, that we are not allowing the customers to withdraw the money of a fixed deposit before maturity, then you can't. But normally what the banks, they do, they deduct a certain portion of the interest, then allow the customer to withdraw the fixed deposit. So when it comes to special type of account, but normal accounts like savings and credit, current accounts, customer at any time can close his account by just giving notice to the bank with not necessary to give prior notice. Clear?
Yes,
Okay.
sir. Thank you.
Okay, right. Then the bank customer relationship comes to end when you close the account. Not like stopping an account. Stopping an account, bank customer relationship continue, but when it comes to when you close the account, bank customer relationship comes to end. Then if banker customer relationship is no more there, what is the situation of the duty of secrecy? You may remember under the duty of secrecy we discussed, even the account is closed, duty of secrecy never finish. So the duty of secrecy will continue even after closing the account. The banker cannot divulge any information of the customer. That is very important. Then the fourth one, I said if you close the account, that is a permanent thing. So therefore, closed account cannot be reopened. If you close the account today, tomorrow you can't open the same account. You can open another account, but not the same account. So therefore, you are creating a new banker customer relationship with the bank by opening a fresh account. But you can't continue the same account because as per the law, when you close the account, the banker customer relationship comes to end. It is a permanent thing. You can't reopen. And then the other important question, the point that you have to remember, that you asked the question also, whether we can accept customers' verbal instruction. Of course, we have to, because legally he can give verbal instruction. And I said, to safeguard the interest of the bank has to get that instruction in writing. So the case is this, Wilson versus Midland Bank. You have to remember this. In this matter, what happened? The customer gave instructions to the bank to close the account verbally. The bank accepted the verbal instruction because they are bound to do so, but they didn't follow up and got that instruction in writing. So that is the mistake they did. Then they later on, the customer challenged the decision of the bank and said he never gave instructions to the bank to close his account. So the bank couldn't establish that they received instruction. There were no evidence. So therefore, ultimately, the bank held liable to breach the duty under the banker's customer relationship. So that's why I say always get that instruction in writing, though you have to accept the customer's verbal instruction. So that is about closing of account. Then the next one, customers right. Any questions? Okay, the customer's right for interest. Yes.
Excuse me, sir. In the previous slide, if customer on the customer request account is closed, then he can't reopen it. So normally we used to close the account if customer not maintain the minimum balance after the particular period. So in that sense, if customer come and deposit some kind of amount, it will be reopened.
Can't do that.
That also can't do. Okay, sir.
No. Can't do that. Right.
No, I had an experience in a small, so just I clarified, I don't know.
No, sometimes customers comes and say that you can't do that, you close my account, you know my my clients know this account, I have issued checks from this account, I want to reopen the account. Can't do that because it's not possible under the law. You can open a fresh account, but not the same account, right? The other thing is, the bank has a right to close the account, but bank has to give a notice, reasonable notice to the customer that we discussed previously. But here the difference is customer, he is not obliged to give notice. He just can give instructions to close the account at any time. At any time, that's the difference. So next one is right to interest. Customers has a right to interest, claim interest. For the deposits account, customer receive interest, savings, fixed deposit, RFC, NRFC, these types of account. He has a right to claim interest. Then rate of interest fluctuate in line with the prevailing market rate. So the market, unless the bank and the customer has agreed an interest rate, the bank can decide the interest rate based on the market conditions. It is the discretion of the bank. However, if you have promised the customer to pay interest, he has a right to claim interest. The rate the bank can decide for normal savings and NRFC, RFC accounts. But special type of account, the bank has no right to change the interest as agreed interest, change the agreed interest rate. What is this? What are the special type of accounts? Special type of account means fixed deposits. In the fixed deposit, the bank has no right to change the interest rate during the period. So for example, we say that we have taken a fixed deposit for a 5 years period and we have agreed to pay, we said 20% interest per annum. So after we say after 2 years, bank, we say now the market conditions are so bad, interest rates have come down. So can the bank now change the interest rate? The answer is very clear. The bank has no right to change the interest rate during before the maturity period of the fixed deposit. And also, we say the interest rate now gone up. Customer also cannot demand to increase the interest rate of a fixed deposit before the maturity. The only thing that the bank or the customer can do or change the interest at the time of the maturity. So you know, when the fixed deposit get maturity, if you have given instructions to renew it, then the the fixed deposit will get renewed with a new interest rate. So at the end, so the next one is a new account. When you're opening the new account, you can agree on a new rate. Therefore, only occasion that the bank and the customer can change the interest rate of a fixed deposit is at the time of renewal. Then the next question is, now you know that the customer deposit money and we utilize that money for investment and other things, and we generate income from that. That is our business. Then the question is whether the customer has a right to know how the bank has utilized the money, where the bank has invested the money, how much that bank has, how much interest the bank has generated, what is the income of the bank. Likewise, whether the customer has a right to ask because we are utilizing his money to invest. So for that, this case is important, Foley versus Hill. In that matter, this customer filed action against the bank and he said that he has a right to know this information, where the bank has invested my money, how much the bank has earned from my money, so how much he has paid to me, what is their profit. Likewise, whether the customer has a right because the bank is utilizing his money, the customer's money. So the matter was argued and ultimately the court decided the case like this. Court said the money paid to the bank ceased to be the money of the customer. The court said once you deposit the money, it is not your money anymore. It becomes the money of the bank. the bank can use the money in the way the bank wants. So once you deposit the money, it becomes the bank money, and the bank can utilize the money the way they want. There's only condition. What is the condition is the bank is only answerable to the customer to repay the amount deposited when the customer demand. So bank has an obligation, only obligation is the bank has to return the money or pay the money to the customer when he demand. So basically we say customer has deposited money to his savings account, we say 1 million, and we have taken that money and we have invested that money in a project for 5 years. Now the customer comes tomorrow and he say, I want to withdraw my 1 million. Now you can't say, as a bank, you can't say, look here, we have invested your money in a project, it's a 5-year project, at the end of the 5 years only that we can't pay, we can pay, until such time we can't pay. That is a breach. So you can't do that. The bank has to pay that money, however, when the customer demands, with the interest that you agree. So that is the condition that you take money from the deposit from the customer. The customer does not have a right to know where the bank has invested the money, how much that bank has earned as a profit. Likewise, this information customer does not have a right to ask from the bank because the money deposited to the account of the customer becomes the money of the bank. So that is the decision of the Foley versus Hill. Any question from this slide? Okay, if you don't have any question, then I'll go to the next one. Customers right, the fifth one, the right to draw checks. The current account holders have implied right to issue checks. The bank has implied duty to honor the customer's check up to the limit of the credit balance. This is very important. If you allow a customer to open a current account, the unique feature, inherited feature of the current account is customer, the account holder, current account holder has a right to issue checks. And it is an implied right. It is not written in any terms of conditions, account opening document, but it is a right. It is a right accepted by courts, which is not written, implied right. And also, the other side of this right is there is an obligation on the bank. What is the obligation? When a customer issue checks, bank has to honor the check. Bank has to honor the check up to the credit limit, up to the credit balance. Or if there is a OD facility has been given, then the bank has to honor the check up to the OD limit. Customer can deposit check to his current account. That is the other right that he has. If he has a current account, he can deposit the checks that he received from others to his account. So the bank has to collect the checks on behalf of the customer. That is a duty of the bank. So with regard to this, this case is important that we discuss under the banker's duties. Joachimson versus Swiss Bank Corporation. In this matter, it was decided customer has to make a demand to repay. That means customer has to issue a check. If you have a current account to withdraw money, that you have to issue a check. And that demand, that check has to be presented to the same branch and during the working hours. So that was a decision that we already discussed this matter previously under the banker's right and duties. Joachimson versus Swiss Bank Corporation, very important case that you have to remember. This case under the customer's right and also under the duties of the banker. So if you have any questions from here, you can ask, or otherwise I'll go. Yes.
Sir, when seizing the account.
Seizing the account, okay.
Then when seizing the account, if bank charges any that means if bank charge is that be recovered after the receiving the ceasing notice?
You mean the ceasing notice, or you are referring to the stopping the account?
Oh, yeah. Stopping the account. Is that different, ceasing or the stopping?
Yes, the stopping of the account means customer give instructions to the bank to stop the account, debit and credit. Normally, when you say ceasing the account, ceasing orders comes from the courts or sometimes custom department or inland revenue department. That is by operation of law. So if you received a ceasing order or a court order to seize the account, then you seize the transaction, debit and credit, as per the seizing order. So then, of course, you can't debit and credit the account, but as you said, if there are charges, that you can recover that charges after lifting the seizing order from the customer. But if it is a stop account instructions, any charge that due to the bank before you receive the seizing or rather the stopping account instruction, you can charge from the customer during the account during the period of account stopped. It is permitted, but if it is a charge that or any fees that you occurred to the bank after you receiving the stop account instruction, then you can't charge during that period. So as you said, once the stop account instruction is lifted, then you can charge that after the period. Clear?
Yes, sir. Thank you.
So do we charge for stop payment?
No, we don't. That is a right of the customer. Any other questions?
Can we recover the loan?
Can you recover the loan?
Loan repayment.
Okay, right. Loan repayment. Now, when you say loan is created, if the loan is created before you receiving the stop account instruction, then the installment due to the bank before you received stop account instruction. So therefore, we are eligible to debit the customer's account and recover the loan installment. But if you grant a loan after you receiving stop account instructions, then you can't recover that loan installment from the account until he lift the stop account instruction. Clear?
Yes, sir. Thank you.
Okay. So then we'll go to the next one. That is duties of the customer. Now, rights of the customer we discussed. Now we see the duties of the customer. Duties of the customer under the banker-customer relationship that he has to perform to the bank or in favor of the bank. In other words, bank has rights for these duties. So what are the duties? Number one, duty of reasonable care. How do you remember? The bank also has a duty of reasonable care. When you are paying checks or collecting checks, that you have a duty of reasonable care to protect the customer from any frauds. Here, the customer also has a duty of care. When the customer has a duty of care, he has an implied duty of care to exercise reasonable care when he gives written orders and instructions. When a customer give written instruction or written orders to the bank, he has a duty of care to so that not to mislead the bank. That is A. B. Not to facilitate any forgery. So that is his duty. Now, when a customer give instructions to the bank, he has to give clear instructions. If that instruction is misleading, the bank has no obligation. That is number one. Then also, the customer, when he give instructions, he has a duty to give instruction which should not facilitate for forgery. If he has given instruction which has facilitated for a forgery, then bank has no liable. Not only written instructions, when he is giving orders also say, what is the order? Order is, the written order, the common written order that we know is a check. Check is an order given to the bank to pay a certain sum of money. So it is a written order. When he gives a written order or check, he has a duty of reasonable care. He should not give a check which is misleading, and he should not give a check which can facilitate for a forgery. If his check is misleading, or if his check has facilitated for a forgery, then customer cannot claim any damages or money of the value of the check from the bank. That is number one. So for that, there is a famous case which is known as London Joint Stock Bank versus Macmillan and Arthur. This is very important. I would say most of the exam papers, this question has come. So there is a high, yes.
Excuse me, sir. There are also questions in message book. Her microphone is not working.
Her microphone is not working. Oh, my one.
Hers.
Can you hear me?
No, sir. The problem is, sir, she is not able to raise a question. Therefore, she sent a text message.
Okay.
She is asking about the dormant account. What I have asked about. So I think you can go to the message.
Okay. So shall I answer to that question at the end of this thing? Because if I go to the...
Fine, sir, because that is related to previous sessions. No problem anyway.
Right. Okay. Thank you. I will answer to that question at the end of the lesson today, since it is relevant to the previous lesson. Okay. So we were discussing about the written, so the customer's duty of reasonable care. So this, I said, this is very important. This case, very important case. It's an exam question. It has come several occasions, and there is a high possibility that it could come this year also. The case is London Joint Stock Bank versus Macmillan and Arthur. This is known as or famous as a Macmillan case, or sometimes they ask what the Macmillan Theory. Macmillan Theory, Macmillan case, or London Joint Stock Bank versus Macmillan. When you are writing the value of the check, it is you are expected to write the value of the check in letters and also in figures. So that is to protect the bank.
Sir,
yes.
Few minutes we didn't hear you, so we all didn't hear you. So can you repeat again from the Macmillan Theory onwards? Because after that we didn't hear anything.
Okay. Can you hear it now?
Yes, sir. Now we can hear you.
Right. Okay. Sorry about the maybe a technical problem. Right. Okay. So Macmillan Theory and the Macmillan Joint Stock Bank versus Macmillan, or Macmillan Theory or Macmillan case, we refer this case as under those names, right? If you get a question like what is Macmillan Theory or what is Macmillan case, all are referred to the same, that is duty of reasonable care of the customer. So what happened in this matter, the Macmillan, the account, he had an account in this bank, he had a current account, so he issued a check. So when we say he issued the check, that is a written order given by the customer. So he issued a check. You know, when you are issuing a check, in a check, there is a space that you have to write the value of the check. Value you have to write in words and also in letters. In letters and also in figures. That is there to protect the from any forgery. That's why there are two. That is why we have to write the value of the check in letters and also in figures. Here, what happened? This person, he wrote the check, but he didn't write the value of the check in words. He kept that in blank. And also, this check, he wrote the value in figures. This is the case decided in England. The currency used in England is pound. After the pound mark, he wrote the value as £2, but he kept a space in between the value. Pound mark, and then he kept a space and he wrote two figures. So now this was given to a person. So the bearer, what he did, he got the check, he put 1 before the 2 and put another 0, and he altered the check. Now the check is altered. Now the value is £120. And also he wrote the value of the check in words also, and it was presented for the payment to the bank. Initially, the drawer issued a check for the value of £2, but he was negligent and he didn't write the value of the check in words, and he kept a space. Now the bearer, he altered the check. He altered the check as 120. It was presented for the payment. Check was paid by the bank. So now the situation is, when the customer checked his account, he saw that the bank has paid £120 instead of £2. So then he filed action against the bank. What was his case? As we know, if the check is materially altered, check is not valid. That is the law. If the check is materially altered, check is not valid. If the check is not valid, the bank cannot pay. Simple as that. So now check has been altered, bank has paid, which is a wrong payment. So therefore the customer demand the money paid by the bank, £120. He said, I issue a check for £2 only, but the bank has paid additional $118. So he filed action. Now you say, when you say £118, remember this case was decided, say almost 100 years before. So therefore £110 is a big amount at that time. So what happened? The court said, even though law says that the altered check is invalid, under the banker-customer relationship, the customer has a duty of reasonable care. He has a duty of reasonable care when he issue checks. But by looking at the way that the customer has issued the check, court said the customer has breached the duty of reasonable care. So court said, if you have breached the duty of reasonable care, the bank has no obligation. So therefore, the customer cannot claim any damages or the money of or the value of the check from the bank. Otherwise, what happened? If there is no breach of duty of reasonable care, if the check is altered, the bank has to pay the value of the check to the customer. In this occasion, Mr. Macmillan's case, he lost, or he lost the case because the court decided that Mr. Macmillan, at the time when he issuing the check, he has breached the duty of reasonable care under the banker-customer relationship. So, do you have any questions from here? Duty of reasonable care? Clear? Okay, so then if you don't have any question, then I'll go to the next one. The next duty is a duty to disclose forgeries. This is the second duty of the customer towards the bank, duty to disclose forgeries. The case is Greenwood versus Martin's Bank. Greenwood versus Martin's Bank. This case is known as Greenwood case, or this sometimes refers as the Greenwood Theory. So whether it's a Greenwood case or whether it's a Greenwood Theory, it refers to the same, that is duty of forgery, duty to disclose forgeries. The customer has an implied duty to inform the bank if he discover any forgery about a check or account. So basically, in other words, in simple words, if I say, if I am a customer, if any forgery has happened in my account, if that information, or rather that forge information about the forge, if it is came to my knowledge, as the account holder, I have a duty to inform the bank at the first instance. So that is my duty. If I breach that duty, I can't claim anything from the bank. So that is the duty of duty to disclose forgeries. So if I explain the Greenwood case, the facts of the Greenwood case, then it will be very clear to you what happened in this matter. Mr. Greenwood, he had an account in this bank, current account in this bank, Martin's Bank. So as a current account holder, he got a checkbook. So his checkbook he kept in at home. So one day when he go through his account statements, current account statement, he realized that some checks have been paid by the bank. So he noticed that those checks he never issued. So then he got his checkbook, and he saw some checks have been issued or have been taken from his checkbook and has been issued, and a bank has paid those checks and someone has taken money. So obviously someone at home has to take checkbook or check leaf from his account. So therefore what he did, he inquired this from his wife. He asked whether you took the checkbook and forged my signature. So then wife admitted that. Wife said, yes, I took money from your checkbook by forging your signature. She said that I took money to help my sister. So then Mr. Greenwood, now it's very clear there is a forgery. Mr. Greenwood came to know about the forgery, but he didn't inform the bank. He advised wife not to do it again, but he didn't inform the bank. So now you see, it's clearly he has now breached the duty to disclose forgeries. So later on, now he just didn't inform the bank, and now he, after another period of time, then when he checked his current account statement again, he saw again there are number of checks that have been taken, money has been paid for a number of checks which he has not issued. Now he knows who takes this money, who has taken the money, because last time he got to know that his wife is forging the signature and taking the money. this time also he asked from the wife, and wife admitted, and this time he threatened the wife that he is going to inform the bank or authorities, because he got angry, and he said that I'm going to inform the bank and the law enforcement authority about this forge. And actually that because of that threat, this wife committed suicide. So now, after the death of the wife, what Mr. Greenwood did, he filed action against the bank. The action against the bank, claiming the value of the checks paid by the bank on forged signatures. So, as you are aware, as per the Bills of Exchange Ordinance, Section 24 of the Bills of Exchange Ordinance very clearly says, if the signature of a check is forged, the check is not valid. Our Bill of Exchange is similar to the English Bills of Exchange Ordinance. So, in the same provisions are there. If the signature of the drawer is forged, the check is not valid. Here, Mrs. Greenwood has forged the signature of Mr. Greenwood. So, therefore, the signature is forged, check is not valid, that bank has paid. So, Mr. Greenwood filed action against the bank, and and he claimed the value of the check that bank has paid. However, in this case, Mr. Greenwood's action was failed because the court decided in this situation, in this case, Mr. Greenwood had a duty to disclose forgeries, but he has not done that. So therefore, he has breached the duty to disclose the forgeries in a situation like that, even though the bank has paid the forged signature checks. The bank is not liable to return that money to the account holder since he has breached the duty. So otherwise, otherwise, what is the situation? The bank has to return the money if the signature is forged. That is about the duty to disclose forgeries. Any questions from here?
Sir, then customer can lie, no? You can say just now only I got to know these kind of things that occurs. In that case, then?
Yeah, actually those are the things that you have to prove in courts by evidence. As you said, the customer can lie, but at the court, the witnesses always, they don't tell the truth, but the lawyers, they know how to tackle the witnesses, right? When they cross-examine the customers or the witnesses, we know how to get the truth out of the mouth of the liars. But again, all depends on evidence. As you said, yes, customer can lie, but in this occasion, it was revealed that he knew that his wife has forged the signature previously, and he did inform the bank previously, and later on, after the death of the wife only, he claimed the money. So that all these came from the evidence. Yes, customers can lie. Any other questions? The principle is clear to everyone, right? Duty to disclose forgeries. If it is breached, the customer cannot claim any damages or any money from the bank under this Greenwood theory. So that is the second one, the customer's duty, the Greenwood duty. Then the next one, customer's duty to check and reconcile his account. The question is, when a customer is maintaining an account in a bank, whether he has a duty to check his account regularly and reconcile his account. If there are any defects in the account, whether he has a duty to rectify those accounts. Now, I have seen when some banks they are sending account statement to the customers, there is a statement printed in the account statement, especially in the backside of the account statement, which says the customer has a duty to check his account statement, and if there are any errors that you observe, that you have to inform the bank immediately. If you don't inform that to the bank within 14 days, that we consider this has been accepted by you. Something like that. Some effect to that. There are statements in the account statement. Question is whether the bank is protected by that printed statement. This has been rejected by the court of law. So court said the bank cannot impose further duties on the customer. Customer has no duty or obligation to check his account or statement and reconcile his account. Who is operating the account? Bank is operating the account. So it is the duty of the bank to operate the account carefully on behalf of the customer. So duty of care is with the bank when they are operating the account. So basically, in other words, we can't, as a bank, we can't operate the account of the customer and cannot put the obligation on the customer and say, we have operated your account. If we have made any mistake, you have to find the mistake and inform us. If you fail to inform our mistake, that you are obliged. So that is not accepted by the courts. Court said it is not the duty of the customer. It is the duty of the bank, because the bank is operating the account. Bank has to be careful when they are operating the account. Any mistake, any errors done by the bank in the account statement, it is the liability of the bank to rectify it. It is not the liability of the customer to rectify it. So therefore, even though you have put any clauses like that, it will not cover the liability of the bank. Still, it is the liability of the bank. It is not the liability of the customer, even though you try to put that into the customer's shoulders. So the important case is Thai Hing Limited versus Liu Chang Hing Bank. So this case is known as Thai Hing Limited case. If you can't remember the entire name, you just remember Thai Hing Limited case. So it was decided reconcile or checking the account statement is not an obligation of the customer. It is an obligation of the bank, and bank cannot put that obligation on the customer. So that is decided in this case. And the same principle has been followed by our courts in several cases. These cases that you can remember easily, that is Keppettigala Rubber Estate versus National Bank of India, and the other case is Collatus versus BOC. In both cases, in our courts also followed the same principle and said, if there are any errors in the accounts of the customer, those errors has to be rectified by the bank, not by the customer, because the account is maintained or operated by the bank, not by the customer. So that is the duty to check and reconcile the accounts. So that is the duties of the customer. There are two duties, that is Greenwood duty and Macmillan duty. Those are very important two duties that you have to remember. And other duties that we discuss, liabilities and duties under the banker-customer relationship. If you have any questions from a bank customer's duties, you can raise now. Right. If you don't have any other questions, I will see. Okay, there's one question that in the the chat box, it says, does dormant mean stopped account or closed account? Can someone answer or ask him? Okay, right. Okay. Does dormant account mean stopped account or closed account? Okay. It's not stopping account or closing account. Dormant account means, as we discussed previously, account there the customer has not done any transaction for a long period of time. He has not given stop account instruction, and the bank, he has not closed the account, bank has not closed the account is open, it is not stopped, but no transaction for a period of time. So that type of account that we categorize as a dormant account for the purpose of monitoring. It's an internal process of the bank. It is nothing to do with stopping account or closing the account. It's a different thing. I believe that answer is sufficient. Some people, I don't know what has happened. Some people say they can't hear, but maybe a technical issue. However,
no, sir, that was occurred a few minutes ago that I informed you earlier.
Right. Okay. Miss, there's another question. Is bank can charge any account closing when the customer gives a letter? Is bank can charge any account closing? Oh, I think you're asking whether we can charge any fees if customer gives instructions to close his account. It all depends on your terms and conditions that you have agreed. Different bank have different terms and conditions. Some banks say they have to maintain minimum balance, otherwise they charge fees. Some banks says if you close account we charge interest. Sometimes some banks charge annual fees. Likewise, if you have agreed to pay a fees, then you can charge, or otherwise if you have not agreed, if you give account closing instructions, bank cannot charge any charge for that or fees for that. They have to close the account. So I believe that is answered. Right, those are the questions that for today. So then we'll finish today's lesson.
Excuse me, sir.
Yes.
There's another one thing. Is there any particular chance that when it comes to, when it's come to check stop instructions, stop payments?
Yes.
So is there any particular chances to claim the damages from the paying bank for the presenting party?
You mean check return charges you are talking about?
No, not check return charges, sir. Let's say that one of our best customers has given advices to stop a particular check.
Okay.
And we have acted according to his instructions.
Yes.
But the presenting party is claiming damages from our bank. So is there any particular
basically you are asking, okay, customer has stopped the payment of the check, and the presenting party, you are asking whether that party, that is the bearer of the check, whether he can ask damages from the bank. No. He can ask damages from the account holder, not from the bank. It's nothing to do with the bank. Bank has to obey by the instruction of the customer. Customer has stopped the payment. So the course of action is against the customer, not against the bank. But if you pay the check without following the instructions of the customer can sue the bank. Clear?
Yes, sir.
Okay. Any other question?
Excuse me, sir. There's a question.
Yes.
The thing is, one of the director of a limited liability company is coming to deposit a large amount value of a check to his saving account.
Okay.
The thing is, the root behind this is the company has further issued some ordinary shares in order to increase its capital.
Company has issued shares to ordinary shares to increase the capital of the company. Yes.
So when the time when it issues the capital, the particular firm it's like a subsidiary acquiring there. So he has issued a check with a large amount. It's like almost 100 million and all. But he's the only director at the particular company. I mean, the particular company, and he is coming to deposit to his saving account. But when it comes to
he's depositing this to his account, right?
Yes, he's coming here to deposit to his saving account.
Okay.
So the thing behind is, how can the for the source document and all, for the proof whether it is an ordinary share has been issued and all, how the bank is there covered by the law to collect the particular check to his saving account? I mean, the customer is demanding, this is behind the scene, and you have to accept the particular check. So how the bank is here covered by the law, or can we accept this check? That's the question.
Okay. Yes. Now what is our duty? Our duty is to protect the right of the customer. So customer is the account holder. So how we can protect the right of the bank or against any claim? So what we have to do is, when we are collecting or when we are paying the check, if there is any suspicion, if there is any reason to suspect, we have to make a query. We have to ask from the person who is depositing the check or presenting the check, from what sources you receive this check. So he has to make he has to give a reason. Whether he is giving the reason that he give, whether he is correct or wrong, it's nothing to do with us. So basically, we have to make a request or make an inquiry. So if he gives a reasonable reason where you can accept, then you have to accept it and you can pay the check or deposit the check. So that is your duty. So if you follow the duty, that you are covered. If you fail to make that inquiry and if you don't accept the check without making any inquiry, that is a breach. That is a negligence. Then only the bank is liable. So otherwise, if customer has lied to the bank, that is his fault, and he is liable for the misrepresentation facts to the bank. Clear?
Sure, sir. Sure. Thank you.
Right.
There's a small doubt there. The thing is, now he is liably saying that we have issued it's regard to an ordinary share issuance. So what are the documents do we have to take from the customer in order to prove that the transaction is beyond with the raising a capital for the company and all?
So if you can get a letter from the customer confirming that he received the money from issuing a ordinary share under his signature, that is more than enough. If someone challenge, you can produce the document that with the signature of the customer, then the customer is liable.
So only the letter is enough, no? So
that is enough. You can't. If it is a single director company, if it is not a public public company, you can't. You don't have the share market documents or anything, no. So it could be a private deal, right? So
sure.
In a situation like that, you can't ask further documents. So what you can do is you can say that you give us a letter confirming the source of funds. So then he will give a letter saying that I raised this I issued ordinary shares and raised the capital of the company. So that you can accept that, and if he lie, then he is liable. So you can produce the document to if there is any dispute, even to the CID or fraud bureau. So that is sufficient document or evidence.
Sure, sir. Thank you. Thank you.
Excuse me, sir. In
Yes.
that scenario, can't we refer the mandate?
What is the relevancy of the mandate?
And because is the company director,
Yes,
so he has to mention why he is using this, opening this accounting and all the details in the mandate, no?
correct.
So then we can identify is what kind of business is doing, how he get
Yes.
income, all the things. So can't we refer that?
Now we can refer that, but here the question is now this director is bringing a huge the value check, which is not an ordinary check. He says 100 million or something like that, and he want to deposit that check to in his account. So if now you have a duty to inquire from the person from where you got that money. Now he says that I have another subsidiary company and we issued ordinary shares to raise the capital. And this is the check or money that I received as from that transaction. So he asks what is the document that we can get from the customer to prove that he got that money from that particular share transaction. So, so we can't go behind the customers and all other relevant parties and get all the documents. What we can do to safeguard the bank, we can get a confirmation from the customer. So based on the customer's confirmation, it is definitely not from the income of the company. He says it's from the share issuance. So that money that we have to accept the customer's word because he is giving that in writing. But if we lie, what will happen? Whether we are liable to that? We are not liable because we are not detective. We don't want to be detectives, but we have to be very careful and be vigilant. So we have done our duty by taking a letter from the customer confirming the transaction.